Welcome to our SQE MCQ Gameshow, SQE1 style questions, in a format you can enjoy. Without further ado, I am passing you on to our hosts, Giannis and SQE the Bot. Hope you enjoy the show.
Okay, SQE, get a load of this. Clever AI bot like yourself shouldn't have any trouble finding the right answer. Tom is driving his car carefully through a residential neighborhood when he suddenly loses control of the vehicle due to a defect in the brakes which he was unaware of. As a result, he swerves onto the sidewalk and hits a pedestrian, Sarah, causing her significant injuries. Sarah decides to sue Tom, seeking compensation for her injuries and medical expenses.
Bravo.
Tom argues that he should not be held liable because the brake defect was a manufacturing fault that he could not have foreseen or prevented. Which of the following principles is most relevant in determining Tom's liability for Sarah's injuries in this case? 1. The principle of vicarious liability. 2. The principle of strict liability. 3. The principle of duty of care. 4. The principle of contributory negligence. 5. The principle of res ipsa loquitur.
Hi, Yanis. Interesting question. Poor Sarah. I think the correct answer is number 5, the principle of res ipsa loquitur. This refers to a doctrine that infers negligence from the mere occurrence of certain types of accidents.
SQE, you surprise me. You got it wrong.
What's going on?
The correct answer is 3. The principle of duty of care. In this negligence case, the principle of duty of care is most relevant in determining Tom's liability for Sarah's injuries. To establish negligence, Sarah must prove that Tom owed her a duty of care, breached that duty, and caused her injuries as a result. In this scenario, Tom, as a driver, owed a duty of care to other road users, including pedestrians. The defect in the brakes may complicate the assessment of loss, but the primary focus is whether Tom's actions fell below the standard of care expected of a reasonable driver. Other principles mentioned are not directly applicable in this context. Vicarious liability involves holding one person liable for the actions of another, typically an employer for an employee. Strict liability applies to cases where liability is imposed without fault. Contributory negligence involves the injured party's own negligence contributing to the harm. Therefore, the principle of duty of care is central to assessing Tom's liability in this negligence case. Let's try a different question and see if you manage any better. Global Tech Limited is a private company that has recently held its annual general meeting. During the meeting, the board of directors proposed a significant amendment to the company's articles of association. The amendment would introduce stricter voting requirements for certain types of shareholder resolutions, effectively reducing the influence of minority shareholders. Jane, a minority shareholder holding 10% of the company's shares, opposed the amendment but was outvoted by the majority shareholders. Jane seeks to challenge the amendment. Which legal mechanism allows Jane to challenge the amendment to the company's articles of association? 1. Derivative action under Section 260 of the Companies Act 2006. 2. Petition for unfair prejudice under Section 994 of the Companies Act 2006. 3. Application for judicial review under the Administrative Court's jurisdiction. 4. Action for breach of director's duties under Section 172 of the Companies Act 2006. 5. Claim for misrepresentation under the Misrepresentation Act 1967.
I am feeling a bit more confident about this one. I am between Section 260 and Section 994. I think the petition for unfair prejudice under Section 994 of the Companies Act 2006 is a better answer. Section 994 provides a mechanism for minority shareholders to petition the court for relief on the grounds that the company's affairs are being conducted in a manner that is unfairly prejudicial to their interests. In this scenario, Jane can challenge the amendment to the Articles of Association by filing a petition for unfair prejudice, arguing that the new voting requirements diminish her rights and influence as a minority shareholder. This section is specifically designed to protect minority shareholders from actions by the majority that are unjust or inequitable.
Well done, SQE, you're right. The correct answer is the second one. The other options are not directly applicable in this context. Derivative actions address wrongs done to the company. Judicial review applies to public law matters. Actions for breach of directors' duties focus on directors' conduct. and claims for misrepresentation involve false statements inducing contract formation. Therefore, Jane's most appropriate legal recourse is to petition for unfair prejudice under Section 994.
How are you enjoying the show so far? If you are finding this useful, hit that like button so it spreads to more people.
As you did well in this last question, SQE, let's try something a bit more challenging. A damages question. Emily is a freelance graphic designer. She has entered into a contract with ABC Publishing to create a series of illustrations for their upcoming book. The contract stipulated that the illustrations were to be completed and delivered by the 1st of May, with a payment of £5,000 upon delivery. Due to unforeseen personal issues, Emily was unable to complete the illustrations by the agreed date. ABC Publishing Limited needed the illustrations urgently and had to hire another designer at a cost of £7,000 to complete the work. ABC Publishing is now seeking to recover the additional cost from Emily. Which of the following statements best describes ABC Publishing's legal position regarding this breach of contract? 1. ABC Publishing can recover the full £7,000 from Emily as it represents their additional cost. 2. ABC Publishing can only recover £5,000 from Emily, which was the original contract price. 3. ABC Publishing can recover the additional £2,000 incurred as it is the direct consequence of Emily's breach. 4. ABC Publishing cannot recover any additional costs because Emily's breach was due to unforeseen personal issues. 5. ABC Publishing can claim for £12,000 the combined cost of the original contract price and the additional cost.
Thanks, Giannis. I think the correct answer is number 3. ABC Publishing Limited can recover the additional £2,000 incurred, as it is the direct consequence of Emily's breach, and they are entitled to expectation damages. Our audience will know that under contract law, when a breach occurs, the non-breaching party is entitled to damages that put them in the position they would have been in had the contract been performed as agreed. These are known as expectation damages. In this scenario, ABC Publishing incurred an additional cost of £2,000 because they had to hire another designer at £7,000 instead of the originally agreed £5,000. This additional cost is a direct and foreseeable consequence of Emily's failure to complete the illustrations on time.
You are right, SQE. Expectation damages aim to cover the loss directly resulting from the breach, not to provide a windfall to the non-breaching party. Therefore, ABC Publishing can claim the additional £2,000 incurred due to the breach, but no more than that. This principle is supported by the case of Hadley v. Baxendale from 1854, which established the rule that damages must be foreseeable and directly resulting from the breach. By the way, if you're preparing for SQE1, especially if you have your eye on the January 2025 sitting, you should subscribe to my newsletter. Email the address you see on the screen right now with the word subscribe in the subject matter to be added to the mailing list. Every subscriber receives a free SQE1 digital study planner to help you organize your time effectively and prepare in the best way possible.
Okay, Giannis, how about I ask the questions for a change? Perhaps you aren't as good as you claim to be. I wonder if you remember business law FLK and can answer the following question. Jane is a director of Tech Solutions Limited, a company that offers IT equipment and related services to other businesses. Jane recently discovered that one of Tech Solutions' key clients, Global Corp, is looking for new software solutions. Jane also runs her own separate software company, Innovate Inc. Without informing the board of Tech Solutions, Jane approaches Global Corp on behalf of Innovate Inc. and secures a lucrative contract for her own company. She is confident that Tech Solutions Limited would not have an interest in offering this sort of software solution to clients, so she didn't think there was anything worth discussing internally. Which of the following statements best describes Jane's position? 1. Jane has not impacted Tech Solutions Limited's interests by securing a contract for Innovate Inc. 2. Jane has no obligation to disclose her personal dealings with Global Corp to Tech Solutions Limited. 3. Jane has breached her duty to avoid conflicts of interest. 4. Jane can only be held liable if Innovate Inc. fails to deliver on the contract with Global Corp. 5. Jane is entitled to pursue business opportunities on behalf of others, so long as Tech Solutions Limited is not interested.
I think I have the answer to this one. Jane has breached her duty to avoid conflicts of interest, which means option 3 is the correct answer. Under Section 175 of the Companies Act 2006, a director must avoid situations in which they have or can have a direct or indirect interest that conflicts or possibly may conflict with the interests of the company. Jane has a fiduciary duty to act in the best interests of Tech Solutions Limited and must avoid any conflict of interest. By securing a contract for her own company, Innovated Incorporated, without informing the board of Tech Solutions Limited, Jane has placed herself in a position of conflict and failed to disclose a potential competing interest. The area of activity does not appear to be distinct in this case. It is not up to Jane to make a determination of whether Tech Solutions would be interested, and the conflict can only be absolved through disclosure, something that has not happened in this case.
Well done, Yanis. I agree. The correct answer in this case is option 3. Shall I ask you another question?
Sure, SQE, go ahead and ask me another question.
You are going to try hard on this one, as the question isn't on the stuff you normally teach. Pay attention to the following. The composition of the House of Lords, with its mix of appointed and hereditary members, has long been a subject of debate regarding its democratic legitimacy. Despite efforts at reform, the fundamental character of the Lords remains unchanged. Which significant reform measure was enacted by the House of Lords Act 1999? 1. The introduction of 26 elected members to represent regional constituencies. 2. The removal of the automatic right of hereditary peers to sit in the House of Lords. 3. The establishment of a fully elected second chamber. 4. The appointment of life peers by the monarch without the advice of the Prime Minister. 5. The expansion of the Lords to include members of the European Parliament.
Okay, SQE, you got me with this one. I should listen again to the Constitutional Law podcast on my YouTube channel, as I'm not sure what the correct answer is. Is it number 1, the one about the regional constituencies?
Epic fail.
You got this wrong. The correct answer is option 3, about the removal of the automatic right of hereditary peers to sit in the House of Lords. The House of Lords Act 1999 represented a significant reform measure by removing the automatic right of hereditary peers to sit in the chamber. While the Act allowed 92 hereditary peers to remain temporarily, it marked a significant departure from the traditional composition of the House of Lords, which had been largely comprised of hereditary members. This reform aimed to address concerns about the democratic legitimacy of the House of Lords by reducing the influence of hereditary privilege and paving the way for further reforms in the future. I am quite shocked you didn't know this one. Perhaps you need a break.
Okay, you got me. Thank you everyone for watching our game show. I'm looking forward to seeing you next time.
So am I. Thank you for watching.
Game over.